I'm Matthew Kingor, Grants Management Specialist in the Office of Sponsored Projects, here today to discuss allocation of rights. This allocation of rights, or AOR document, is a non-monetary agreement establishing the rights between parties to existing and future intellectual property. First, what is intellectual property? These are the legal rights relating to inventions, patent applications, patents, copyrights, trademarks, masks, works, trade secrets, any other legally protectable information, including computer software. Background intellectual property, or BIP, is any intellectual property that's developed prior to or independent of the reference project. And it is important to identify relevant background IP in the AOR in order to ensure there are no conflicting rights, no questions as to who owns the BIP, especially if it's incorporated into the project, and to specify uses of the BIP. Foreground intellectual property, on the other hand, is IP made or generated during the performance of the project. And this will be a product of the project, and ownership is going to be determined by the AOR and subsequent agreements. So generally, IP is addressed in an award document in conjunction with the rest of the terms and conditions. When it's necessary to establish IP rights up front or prior to an award agreement, an AOR is used. So an AOR typically grants each party use of project IP non-exclusively and without compensation for the performance of the project. It also contains an option to negotiate an exclusive license in a separate agreement. If you're submitting an SBIR or STTR proposal, an AOR is required before an executed letter of commitment is provided by our office to the company. And this is necessary to ensure that all that background IP is identified and protected while also establishing rights to resulting foreground IP. As a member of the University of Texas system, IP generated by UT Dallas employees is owned by the Board of Regents. We cannot assign rights to IP through an AOR. Since SBIR and STTR proposals are federally funded, the Bayh-Dole Act set forth at 37 Code of Federal Regulations 401 applies. What we invent, we own, and what the other party invents, they own. Jointly created inventions are jointly owned. So if you have any other questions about AORs, please reach out to your grants and contract specialist, or if you don't know which specialist is assigned to your department, email osp@utdallas.edu and someone will respond.